Chapter 1. Nature of British Constitution. England has no constitution. The French writer, de Tocqueville, who visited England in the middle of the last century to study the working of the English government, remarked that England has no constitution. An American visitor, familiar with the constitution of his own country, on landing in England, asked for a copy of the English constitution. He was surprised to know that no such document was available. Does this mean that England has no constitution? Really, therein be no state without a constitution. A constitution consists of those fundamental rules which determine and distribute functions and powers among the various organs of the government, as well as determine the relations of the governing authorities with the people. If these rules and principles are written in the form of a document or documents, it is called a written constitution. If not, it is then an unwritten constitution. Most of the modern constitutions are written ones. The only exception is the English Constitution, which is an unwritten one. So de Tocqueville, who understood by constitution to be a written document, concluded that England had no constitution, for he could see no written document describing the fundamental laws of England. He did not bear in mind that a constitution can also be unwritten. In this sense, England has a constitution. Professor Munro has defined it thus: it is a composite of charters and statutes, of judicial decisions, of common law, of precedents and usages and tradition. It is not one document, but many. It is not derived from one source, but from several. It is not a completed thing, but a thing which is still in the process of growth. Element of English Constitution. English Constitution consists of the following element. 1. The constitutional landmarks. A large part of the English Constitution is written in the form of constitutional landmarks and statutes. The great constitutional landmarks are the Magna Carta of 1215, the Petition of Rights, 1628, the Great Reform Act of 1832, the Parliament Act of 1911 and 1949, etc. But these laws cover only a small part of the Constitution. 2. Statutes. These are the laws made by the Parliament over many centuries. Some of them relate to the methods of elections, duties of officials, etc. Such laws are also of constitutional significance. 3. Judicial decision. The law courts interpret charters, statutes, etc. These interpretations are also a source of the Constitution. 4. The common law. This is also a source of many constitutional customs and rules, especially relating to the liberty of the subject. 5. Conventions. The conventions of the Constitution are the unwritten rules, usages, and practices. They are an important part of the Constitution. Salient features of the English Constitution. English Constitution is unique in the world, as is shown by its characteristics and features mentioned below. Unwritten Constitution. English Constitution is unwritten. It means that no single document, adopted by a constituent assembly, contains the entire Constitution. On the other hand, it is embodied in various constitutional laws, statutes, judicial decisions, conventions, and usages. Some of these are written, like the statutes and laws, while others are unwritten, like the conventions of the Constitution. This was the implication of the famous aphorism of de Tocqueville, that England has no constitution. There are many laws which are written, such as the Reform Act of 1832, the Parliament Act of 1911, the People's Representation Act of 1949, etc. But they tell us only about a part of the Constitution, and not the whole. However much we study them, we cannot understand fully the nature and working of the English Constitution, unless we supplement our knowledge by a close and careful study of the conventions, usages and other unwritten principles of the Constitution. It means, therefore, that the English Constitution is really a partially written and partially unwritten constitution. Continuity of the English Constitution. English Constitution has unbroken continuity of growth and development over a period of more than 1,000 years. Although the country has been invaded and ruled by the foreigners, and had internal revolts and revolutions during this long period, yet its continuity has remained unbroken. At no moment has the tie between the present and past been wholly rent asunder, writes Freeman. At no moment have Englishmen sat down to put together a wholly new constitution, in obedience to some dazzling theory. Each step has been the natural consequence of some earlier steps. Unlike the Frenchmen, English people have developed their constitution from precedent to precedent, and from past experience of law and practice. Each improvement was made as a result of a felt need and a practical necessity. Moreover, it was more a result of an adjustment of some earlier tradition and usage than an influence of some newfangled theory or philosophy. The unbroken continuity of the Constitution is due to three factors. Firstly, the geographical isolation of England, which has enabled the English people to develop their national institutions without any interference or disturbance by foreign invasion and rule. Secondly, the national character of the British people, who are a law-abiding conservative people with a dislike for arbitrary exercise of authority. Thirdly, the peculiar genius of the Constitution. These factors are also responsible for the flexibility and perpetual growth of this Constitution. Flexibility. English Constitution is flexible. It means that Parliament can amend the Constitution by ordinary legislative procedure. It can be changed in the same way, and by the same Parliament as makes ordinary laws. For instance, Parliament can pass a statute dealing with the changes in succession to the throne, or a law relating to railway company or university. No special procedure, and no special constituent assembly is required to make changes in the Constitution, as is the case in rigid constitutions. The real meaning of flexibility of the Constitution is that it makes no distinction between ordinary and constitutional law, and that it proclaims the sovereignty of Parliament. In this sense, the English Constitution is quite different from the American Constitution, in which the Congress is not a supreme body, and the Constitution cannot be amended by the ordinary legislative procedure, because it is the supreme document, distinct from all legislative acts. The sovereignty of Parliament makes the Constitution flexible, because Parliament can make any law, constitutional or ordinary, whenever it likes. A unitary constitution. England has a unitary constitution. All powers of the state are concentrated in the hands of a single government for the whole country. All local governments are the creatures and servants of the central authority, which has created them, and can abolish them at its discretion. In the English Constitution, Parliament is sovereign. Its laws prevail over the whole country, and are supreme over persons and associations within its boundaries. In this respect, the Constitution of England is different from the federal constitutions of the USA, or Pakistan. Its unreality. One of the unique features of the English Constitution is what is called its unreality. There is a great difference in the appearance and reality of the Constitution. Sir Sidney Low has aptly remarked that there is a great divergence between the theory and practice of the English Constitution, and that in it nothing is what it seems or seems what it is. For instance, it is an absolute monarchy in theory, as it actually was during the Tudor period, but in reality it is now a democratic state ruled by Parliament elected by the people. Language of the Constitution still preserves the old and archaic forms of absolute monarchy. For example, the Queen appoints ministers, but really speaking they are chosen by the Prime Minister and formally appointed by the Crown. These unrealities, this wide divergence between theory and fact, render it peculiarly difficult to analyze, or to describe the actual working of the English Constitution. The reason is that British Constitution is always in a state of constant metamorphosis or change, which convert those parts or institutions of it which were once efficient, as Badger calls them, into ceremonial ones, by draining off efficient, practical functions until they become little more than formalities. This is what has happened to the monarchy in the 17th century, to the Privy Council in the 18th, and is happening to Parliament in the present, and is likely to happen to the Cabinet in the future. These crucial metamorphoses are responsible not only for the continuity, but also for the unreality of much that is known as the British Constitution. Constitutional structure of Great Britain is aptly described as a vast and rambling edifice, without any system or symmetry. It is full of anomalies which the English people love to retain. That is why there is a gap between constitutional theory and governmental practice, which is both a source of trouble and charm for the students of the English Constitution. Supremacy of Parliament. Parliament is supreme and sovereign. It can make any law, whether constitutional or ordinary, a distinction which does not obtain in English Constitution. It is said that the English Parliament can do anything except make a man a woman and vice versa. Badger had once remarked that English Parliament can abolish monarchy and establish republic in the country. The sovereignty of the Parliament is really a source of the flexibility of the Constitution. Nature of the conventions. One of the unique features of the English Constitution is the existence of a large number of conventions, usages, and customs in it. No one can properly understand this constitution without carefully studying them. They exert a subtle influence on various branches of the English government. A large part of the working of this governmental system depends upon conventions and customs, rather than upon laws, statutes and judicial decisions. The conventions of the Constitution may be defined as those customs and understandings by which the rulers or members of the British government exercise the discretionary powers of the executive. They form a part of Constitution, but they are not laws because, as such, they cannot be enforced by a court. They are unwritten rules of the political morality, but are regarded as sacred as law, yet are not enforced by the courts. Ogg has defined the conventions as the customs, habits, usages or practices which by their sole authority, regulate a large portion of the actual day-to-day relation and activities of the most important of the public authorities. They are not written or recorded, but are well known and understood by all those who run the government of the country, and are scrupulously observed by the ministers. Examples of convention. Some of the most important conventions are the following. 1. A ministry which is outvoted in the House of Commons is bound to retire from office, or it may appeal to the country by dissolving Parliament. If the people vote against the ministry, it must resign. 2. The Prime Minister should sit in the House of Commons. 3. The ministry should be chosen from the majority party and its leader be the Prime Minister. 4. Parliament must meet at least once in a year. 5. A bill must be read 3 times in each house before it is passed. 6. The bill must be presented before the Queen for the signature which shall be given. Advantages of conventions. Firstly, conventions in the British Constitution are like lubricants in an engine. They help the Constitution to work smoothly. Secondly, they enable the ministers to exercise the discretionary powers of the sovereign. As Dicey says, they are the rules for determining the mode in which the discretionary powers of the free ought to be exercised. Thirdly, they give the Constitution the quality of flexibility or adaptability to new conditions and changes. Thus they enable it to meet new needs and demands, strains, and stresses of the national life and lend itself to political changes without breaking under new political pressures. As Dr. Jennings puts it, conventions provide the flesh which clothes the dry bones of the law. They make the legal constitution work. They keep it in touch with the growth of ideas. The Constitution does not work itself. It has to be worked by men. It is an instrument of national cooperation, and the spirit of cooperation is as necessary as the instrument. The constitutional conventions are the rules elaborated for effecting that cooperation. Also, the facts of a constitution must change with the changing circumstances of national life. New needs demand new emphasis and a new orientation, even when the law remains fixed. Men have to work the old law in order to satisfy the new needs. Constitutional conventions are the rules which they elaborate. In short, the conventions are the motive power of the British Constitution. British Cabinet works on them, and the working of the Parliament has been democratized by them. British judiciary has been revolutionized by them, and, in recent times, they have enabled the ever-increasing dominions to collaborate with the United Kingdom. If by a magic wand the British people were made to forget them altogether, they will soon find that their constitution is unworkable, and their governmental system will then crumble to pieces. Sanction behind the conventions. As we said above, the conventions are not enforced by the courts. Why are they obeyed? Then, what is the sanction or force which compels obedience to them? There is no unanimity of opinion among writers regarding the reasons why they are obeyed, or the force behind them. According to Dicey, the conventions are obeyed because they are based on and sanctioned by the law of the land. Power behind the conventions is the power of law. If, says Dicey, convention is not obeyed, this will almost immediately bring the offender into conflict with the courts and the law of the land. He gave the example of a convention, namely, that Parliament is to meet at least once a year. Now suppose a ministry does not summon Parliament for 2 years. The result will be that no budget will be passed, and the ministry will not be able to collect taxes legally, and so will land itself into difficult circumstances. Hence, although it is only a convention that Parliament must meet at least once a year, it has now the force of law behind it, because by disregarding it public officials would be forced to perform illegal acts. According to Lowell, conventions are not obeyed out of the fear that their breach would sooner or later involve a breach of law, but because they are a necessary moral code for conducting the business of the state. As he puts it, England is not obliged to continue forever holding annual sessions of Parliament, because a new Mutiny Act must be passed, and new appropriations made every 12 months. Parliament, with its plenitude of power, could as well pass a permanent Army Act, grant the existing annual taxes for a term of years, and make all ordinary expenses charged on the consolidated fund out of which they must be paid now without annual authorization. So he concludes, in the main, the conventions are observed because they are a code of honor. They are, as it were, the rules of the game, and the single class in the community, which has hitherto had conduct of English public life almost entirely in its own hand, is the very class that is peculiarly sensitive to obligations of this kind. Moreover, the very fact that one class rules by the sufferance of the whole nation, as trustees for the public, makes that class exceedingly careful not to violate the understandings on which the trust is held. Dr. Jennings points out yet another sanction behind the conventions of the Constitution. It is the willingness of the people to obey them, or at least their general acquiescence to observe them. The force behind is the same as behind the laws, that is, the knowledge that cooperative effort in human life is possible only whenever one does his function or duty according to the laws and customs. According to Ogg, the sanction behind the conventions is the force of public opinion. They are obeyed because public opinion demands that they must be obeyed, for it will not tolerate their violation. For instance, public opinion expects that a ministry defeated in Parliament must not continue to hold office when it has lost the confidence of Parliament. We conclude, conventions are observed because they are the rules of game and a code of honor. Political power in England is a trust in the hands of the rulers. They must observe the conventions, otherwise they will lose the confidence of the nation. Briefly speaking, the sanction behind the conventions is threefold. I. The force of law. The breach of a conventions results in the violation of a law. II. Respect for conventions, felt by the ruling classes of England. And III. Public opinion.